I'm ORVILLE, and we have a question from a viewer. The question today is, can a spouse file copyrights, trademarks, and/or patents on intellectual property created by the other spouse and eventually make money on them? The creating spouse is afraid to create anything new until after the divorce is final, fearing the other spouse, will demand part of anything created prior to the divorce becoming final. Well, the first thing you should know about divorces is divorces aren't created by the federal government. The laws governing divorce in the United States are governed by the states. So each law governing divorce will be governed in the state in which the divorce takes place. Now, as far as the law as to copyrights, trademarks, and/or patents on the intellectual property, if it was created during the marriage, then it will be held to be marital property, which means it would be jointly owned property. The author of the song, and whoever creates the song is the author of the song unless he assigns that to a third party, he has the sole right under the copyright law whether to exploit that song and how to exploit that song. So the spouse would not have the right to go to copyright that song with the U.S. government, although the copyright, you don't have to file in the U.S. government to have a copyright. Whether to exploit that song, to license that song, to do anything with that song, the spouse would not be allowed to do that. Now, if they stayed married, if they didn't get a divorce, she would be an heir, and once the writer dies, his heirs become the author of that song, and they inherit the right to decide what's going to be done with that song unless it's been assigned. Now, as far as the question, as far as the songwriter being to create anything while he's in the marriage, she will be entitled to a share of the revenue. Now, what that share of the revenue is going to be, in most states it's going to be presumed to be 50-50. But at that point, there's going to be either it can be changed. That's not a law that is black and white letter law. It can be changed by either the parties reaching an agreement as to what the split on the income from that copyright will be if it's exploited, or if it's a patent, or if it's a trademark, but we're basically talking about copyrights at this point. If it's going to be split, it can be split differently than 50-50 if the two parties agree. Maybe they're trading off 50% of the copyright or 50% of the income from the copyright for some other asset in the estate in the divorce, so they take a lesser share, or they go through a mediation proceeding, and where the mediator, based upon the mediation, they decide to take some other less than 50% because they think they'll come out better by taking the mediation, and well, it's only a suggestion by the mediator or an opinion by the mediator. It's not binding. They feel that they will come out better if they accept the mediator's opinion than if they go to a court of law. The last resort, as far as how the money is going to be split, would be in a court of law. And at that point, they take into certain factors, and it would, again, depends upon the state, how they're eventually going to divide that, but certain things as who was the one that was most responsible for this asset being obtained, or this intellectual property being created. Well, in this case, unless otherwise said in here, that the wife probably had nothing to do with writing the song. So if she had nothing to do with writing the song, maybe she doesn't deserve 50% unless she was bringing in a comparable amount of income that he's sharing in, and so all the money's going into the estate, and they're splitting everything 50-50. There's certain factors that you're going to have to turn in, and that's why I say in any case like this, now what if you don't create anything during the divorce, then you haven't got anything to shop to try to get cut during this period. And if you're under a publishing agreement, you may be put in suspension because you haven't written anything, because the divorce may take a year, may take 2 years, may take 3 years. So in a situation like that, most songwriters under songwriter deals have a certain amount of songs that they have to write each year, or they stop getting paid their advance. So maybe that's your only source of income. So you may have to have a trade-off on whether you take a chance of what percentage of income she's going to get from your copyrights, from the revenue of your copyrights, or are you going to be placed in suspension with your publisher and therefore not get any advance money or draw money, which will be recoupable from your earnings. It really all depends upon the facts of the case, whether you can work it out with your wife with a marital property settlement agreement, which should always be looked over by an attorney, someone who's very experienced not only in domestic law, but also in copyright, trademark, or patent law, depending upon the intellectual property you're dealing with, because they're not usually, in a domestic case, are intellectual properties involved in that case. So someone that has experience, or someone that is an experienced domestic lawyer that is going to bring himself up to date on what the laws as of intellectual property are, is someone you should be consulting with. But it's very dangerous to be trying to represent yourself in any type of divorce case, especially one where there's intellectual properties involved. And the split is going to depend upon the state law of whatever will be put into practice as far as offsetting the 50-50 presumption of ownership and therefore the revenue. But as far as the spouse being able to exploit the song without the permission of the person who created the intellectual property, you're not going to have to worry about that.